This week's lecture will discuss how paternity is established and the obligation for financial support. Historically, the marriage of parents determined paternity. A child born to married parents was considered their legitimate child, even if the husband was not the biological father. Children of unmarried parents, on the other hand, were considered the children of no one. Because these children were considered illegitimate, there was no duty of support by the biological parents. This notion evolved, and because maternity can easily be proven, children of unwed parents were considered the obligation of their mothers. In the early 19th century, states began to legitimize children whose parents married after their birth. In 1968, the Supreme Court declared that the Equal Protection Clause protects children of unwed parents from being treated differently. Cases also emerged regarding the equal protection of unwed fathers. The Biology Plus approach states that the biological paternity of a father is not enough to make him a parent. Unlike mothers, fathers have to demonstrate their ability to parent a child. There are two ways that paternity can legally be determined. When a child is born, hospitals are required to provide paternity establishment procedures. This is often done through a notarized acknowledgement of paternity, where the father waives his right to genetic testing and states, under oath, that he is the father of the child. The other way to establish paternity is through an adjudication or court finding of paternity. Often these cases are filed by the state agency who is looking for contribution from the non-custodial parent for aid received by the child. Another situation that arises regarding paternity is the issue of sperm donors. For heterosexual married couples, the husband can be declared the natural father even though he is not biologically, if he executes a written consent to her insemination. For lesbian couples and single women, the result is not as clear. In some jurisdictions, the fact that a man has donated his sperm to a facility does not show his intent to become a parent. In others, he can be declared the father through a paternity action. Traditionally, child support was seen as a responsibility for fathers. Mothers had a duty as well, but only if the father did not provide support. States have now made it a crime to fail to pay child support. The purpose behind these statutes is to not only encourage parents to be responsible, but also to prevent children from having to rely on the state. Each state has a 4D agency that is responsible for child support. 4D agencies are required by federal statute to provide 5 services to custodial parents. These agencies establish paternity if it has not already been established, establish child support, review child support awards, enforce child support awards, and locate absentee parents. Custodial parents can qualify for 4D support in one of two ways. First, if a custodial parent applies for TANF, or Transitional Aid to Needy Families, they are referred for child support services. Any child support award is then transferred to the state. Depending on the amount of child support and amount of aid, the state may choose to keep all of the funds or disperse the remainder once the state's aid has been reimbursed. If the custodial parent does not receive TANF funds, he or she can still apply for assistance. Unlike those who receive state assistance, private applications may be charged an application fee. Child support is not captured by the state in these cases because there are no state funds to reimburse. Child support guidelines have been left up to each individual state, although there are 3 ways that child support is determined. The first is based on the percentage of income. A certain percentage of the non-custodial parent's income is set aside for child support. In the second method, the total income of both parents is combined, and then a percentage of responsibility is attributed to each. Finally, under the Melson formula, the non-custodial parent is allowed a minimum level of income. Any amount over that level must be allocated to child support. Each of these methods is based on income, but what is income? Regular wages from employment are always counted as income for purposes of child support. Overtime and other sporadic income may also be included depending on the state. If a parent is not working by choice or is working fewer hours than they are able to, income can be imputed to them. For example, Jane is working 20 hours per week at minimum wage, even though she voluntarily left a full-time job making $12 per hour. Jane's income would then be imputed as $480 per week, or 40 hours times $12 per hour, rather than her actual reduced salary. Income base refers to the amount that is used to calculate a support obligation. Gross income, adjusted gross income, and net income are all possible ways to determine the income base for support. Gross income includes income prior to any deductions. For adjusted gross income, taxes and previous support obligations are deducted prior to the calculation of child support. Net income base allows for other deductions, including voluntary payroll withholdings. Besides income, there are a variety of additional factors that can affect the child support obligation of a parent. Joint physical custody can reduce the support obligation because child support guidelines usually assume that only one parent has custody of a child. If a child receives government benefits or benefits from a trust, for example, a parent's support obligation may be reduced. In some states, a parent's new spouse or partner's income can also be considered because the parent then has additional financial support. The income of the custodial parent is used in all states except those that have adopted the percentage of income approach. Child support guidelines also assume that support will cover all basic, everyday care of a child. Extraordinary expenses generally include education, healthcare, or daycare expenses. Non-custodial parents are sometimes able to deduct the healthcare premium paid for the child from their child support obligation. Finally, some states consider the support of subsequent children in their calculation. There is disagreement, however, as to which children receive the first priority for support, the firstborn or subsequent children. All of this information is required to be included on a financial affidavit and submitted to the court. States have enacted several measures designed to curb the problem of non-payment of support. Automatic income withholding is common, but can only be used when the non-custodial parent has a legal source of income and provides updates as to employment changes to the court. States can also place a lien against the non-custodial parent's property in order to pay any arrearages or past due payments. Non-payment of support is also reported to credit agencies and appears on the parent's credit report. Most states suspend the license of a parent who fails to pay child support, but some states also allow for professional and sporting licenses to be suspended as well. Another way that child support can be captured is the Federal Tax Offset Program. Under this program, the federal government can intercept federal tax refunds in order to apply the funds toward any missed payments. If the arrearage is $2,500 or more, the parent can be denied a passport. Two federal acts also provide guidance as to how child support can be enforced. The Uniform Interstate Family Support Act and the Full Faith and Credit for Child Support Orders Act require that only one state issue a support order for a child, but that all states are required to enforce that order. A state must have jurisdiction over the non-custodial parent prior to issuing an order. Child support orders continue to be modified only by the issuing state. State courts also have two options for the prosecution of parents who fail to pay child support. Contempt actions can be filed if the parent violates a valid support order. These can be either civil or criminal in nature. Civil contempt actions set a purge amount. If the parent pays that purge amount, he or she can avoid jail. The purge amount is then applied directly to any unpaid support, although the court may deduct certain fees. Criminal contempt, on the other hand, imposes a jail sentence as punishment for noncompliance. Similar to contempt, criminal non-support requires proof that the parent willfully or purposely failed to pay child support. Some parents even employ private child support collections agencies, although these agencies may charge up to half of the recovered amount as fees for their services. Child support orders are issued based on a particular set of circumstances. Chances are that salaries, custody, visitation, or other facts have changed since the child support was determined. Either parent can file a modification action requesting that the child support either be increased or decreased. The party requesting the modification has to prove that there has been a change in circumstances that requires a change in child support. Even if the parents do not request a modification, there is a right to have the child support reviewed every 3 years to take into account any cost of living changes.